Sentencing is the most important part of any federal criminal case. It's not about the plea bargain, it's not about the offer, it's about sentencing. So let's break this down. As soon as you find out that you're under investigation for federal charges, that means if you have had a search warrant executed at your house or business, if you've received a target letter from the feds, if you hear gossip in your business realm world that people are being interviewed about you, if people have come, feds have come, knocked on your door, left a business card to say they want to talk to you, you know you're under federal investigation. It is at that moment that you want to find an experienced federal criminal defense attorney and make sure that this person practices in federal court, that they're not just a criminal lawyer. There are a lot of great criminal lawyers out there that don't practice in federal court. It is a completely different system than state court. Working with U.S. attorneys is completely different than working with district attorneys. So you need that experience so the person can guide you through the process. And I'm going to break down that process. So if you have committed a crime and somebody comes and lets you know one way or another that you are under investigation, the first thing you want to do is tell your lawyer everything. Your lawyer can't help you if you are not completely honest with them. Everything you tell your lawyer is 100% confidential. They cannot share that information with anyone without your express authority. So be completely honest with your attorney so that your attorney can guide you and tell you what the next steps are. The other thing that most people don't realize is that more than 98% of federal criminal cases result in a guilty plea, which means that more than 98% of federal cases result in sentencing. A very small percentage of federal cases go to trial, and a very small percentage of federal cases that go to trial result in an acquittal. So most federal cases do result in a sentencing hearing, which is why this is the most important part of any federal criminal case. So you want to start working on your mitigation right from the start. The first thing that you can do if this case involves drugs or alcohol, or if drugs or alcohol were a motivating factor in your behavior, you want to get into treatment. If it's a sex offense, you want to maybe do a sex offender treatment program. If there's gambling involved, you maybe want to go to Gamblers Anonymous. So these are all things that you can do to start. You want to get character letters from people that know you and love you. These letters must include the fact that they know that you have been charged with this crime. If a judge gets a letter that's just written like a prospective employer is going to read it, the judge doesn't care, because you can imagine that judges receive thousands of these letters every year. So this letter, to be particularly impactful at sentencing, has to say, so-and-so told me about the charges. He or she is extremely remorseful. This is so out of character for them, and that you know what they intend to do in the future. And the judge then gets a sense that the people in this person's community are going to be looking out for them. They're aware of the fact that they screwed up once. They're not going to let them do that again. So it's important for the judge to know that people know about your offense. Obviously, this is something that you don't want to share with just anybody. So it's not really a matter of the quantity of letters, but the quality of the letters. That's very important, and it takes time to get people to write these letters. You have to follow up with them. So this is something you can start doing very early on. The other thing that is very important to judges in any kind of a case where there's money involved is restitution. Restitution meaning paying the money back. So if you don't have any money, you set aside whatever you can. Because when you say you're sorry to the judge, I've heard federal judges say this several times at different conferences where judges have spoken and said, you know, somebody gets up there and they say, I'm sorry, but what have they done to show me that they're sorry? So even if they put away $100 a month and they pay back, say $5,000 or $1,000 at the time of sentencing to show that they really truly are remorseful, that helps. Now, is it better on a $5 million case that you pay back more than half of it? Absolutely. And most times the government will seize a gigantic amount of money if you still have it. So that's a different situation. But you want to do whatever you can. Also, if you're driving a fancy car, living in a fancy house, you want to minimize your expenses, because the judge is going to look at that. It's going to be in the pre-sentence report. They're going to see where you live. They're going to see how much you pay in rent or mortgage, what you drive, how much you pay for your lease. So if you're driving a Range Rover and paying $1,200 a month for that car, you need to get rid of it and go get a Honda. I'm serious. These are actually things that judges look at sentencing if it's a financial case and there is restitution owed. So a lot of people think that plea bargaining is the most important part of the case, and it really isn't, because U.S. attorneys are going to, for the most part, they're going to give you a guidelines offer. That means they're going to look at the federal sentencing guidelines, they're going to figure out where you are in that chart, they're going to look at all of the enhancements, they're going to add whatever is applicable, because they have to, and probation's going to do it anyway, and that's going to be the offer. So people often will say, well, can you go back and negotiate with them? Most of the time, no. Most of the time, the offer is the offer. That is when the work begins, though. That is when your lawyer will start to argue the 3553A factors. So those factors include the nature and circumstances of the offense. So what led you to engage in this behavior? How did you get involved? How did it come about? And what really was your involvement? Because sometimes a factual basis in a plea agreement is going to say that you did this, that, and the other thing, and you didn't. And you're going to swear under oath at the plea hearing that this is what you did, that these facts are true. So that is something that your attorney can work on with the U.S. attorney and say, well, this isn't accurate, we need to change this. So the facts are the facts, but maybe they're not quite as egregious as it looks, or maybe you were led to do this for some extraordinary reason. The next factor in the 3553A section statute is history and characteristics of the defendant. That is where the majority of the attention goes. So when you write your letter to the judge, which you're going to write, which is going to express your remorse, it's also going to lay out your entire history. So let's talk about the letter, and then we'll jump back into the 3553A factors. The letter is a letter that you're going to write to the judge that is going to go to the probation officer before your pre-sentence interview, so they can cut and paste for your letter and put it into the pre-sentence report, and the judge reads that first. But also it is going to be attached to your sentencing position paper that your lawyer files for you before sentencing. So your letter, first and foremost, is going to have your expression of remorse. Not I'm sorry to my family, not I'm sorry to the court. That's something that the judge hears every single day 1,000 times, and they don't care. Their eyes glaze over when you say that or when they read that. So you want to talk about the harm that was caused by your conduct. So for instance, if this was a Ponzi scheme and you took money from people and it was their life savings, you want to talk about that. You want to face it. You want to say, I ruined these people's lives. I can't sleep at night. This is unbelievable. I can't believe I did something so crazy, and I feel horrible, and I will spend the rest of my life working to pay these people back. That's the kind of thing a judge wants to hear. But then you want to show them what you're doing to take steps to become a better person. Are you in therapy? Are you in rehab? Are you paying restitution? So the next step of your letter after remorse is your personal background, not as an excuse, but you wanted to go into great detail about your past. Was there abuse in your family? Was there molestation? Was there alcohol or drugs? Did your parents go to prison? Was there some traumatic event that occurred in your life that led you to where you are? At the same time, you want to talk about all of the good things that you've done in your life. If you've received a degree, if you've done community service, if you volunteer, if you've raised funds for a good cause, if you've helped your neighbors, whatever it is that you've done that's good, that has to be in the letter too. And the last piece of the letter is, what are your plans for the future? Because a judge is going to want to know why you're not coming back to their court. Am I ever going to see this person again? Tell me why. Tell me what your plans are. And especially if there is an addiction involved, you want to talk about your plan for treatment. So this is all very, very important stuff that you want to put in your letter. And that will cover the nature and circumstances of the offense and the history and characteristics of the defendant. So those are the two most important factors, along with restitution, where you can potentially reduce your sentence. And we call it a downward variance from the sentencing guidelines. We used to talk about departures. That was the old days. Now we talk more about downward variances, because the judge starts with the sentencing guidelines. And they have discretion to go down as low as they want or as high as they want. And you don't know what a judge is going to do, which is why it's critical that you give them as much information as you possibly can at sentencing so they can make a decision based on who you are as a person, not just another case after, however many years they've been on the bench and however many cases they hear every single day, week, month, year. You want to stand out as somebody who is extraordinary. I've had judges say, this is the best letter I've ever read, or that is extraordinary. I really commend you for the efforts that you've made with respect to restitution or rehabilitation or whatever it is that you've done to stand out. But you need to do the work. You need to stand out at sentencing so that your lawyer can argue all of these things for you. So cooperation, of course, is another way that you can get a sentence reduced. And that means being completely honest with the government, accepting responsibility for your part in this offense, and then giving them information that they don't already have. It has to be substantial assistance in the prosecution of another. So it can be someone in your case or somebody in another case, but it has to be something they don't already know. So just regurgitating the facts in your discovery isn't necessarily going to help you. But you won't find out how many levels the government is recommending off until right before sentencing. So it is a leap of faith, but in my experience, the government is not going to renege on their promise. They are going to give you cooperation credit. I just can't tell you how much. And it is different in every court. It is different in every district. Every U.S. Attorney's Office has a different way of measuring what number of levels they are going to give a particular defendant. So sometimes even you won't get cooperation credit because they weren't able to arrest anyone because maybe they were out of the country, but they'll give you a downward variance for trying. So there are many different ways to get to the end result that you want. So again, sentencing is ultimately going to occur in more than 98% of federal cases, and there are so many things that you can do to mitigate or to reduce your sentence potentially at the end of the day. And that is the goal. And I have a ton of videos on sentencing in my YouTube library, so please take a look, and I hope that this was helpful.